Okay, so hello and welcome to everyone joining us for today's webinar. My name is Laura Dean and I studied my LLB at Brighton in the UK and have been working at Eltoma for just over 2 years now. I'm currently at the Limassol office in Cyprus today. And I'd like to draw your attention to the chat box on screen. So if something is unclear or you would like further clarification on anything mentioned today, please feel free to submit your questions and I'll be happy to elaborate by replying to you with the email that was used to sign up. And if you'd like more information about any judgment or ruling, looking at the case law will give you a really in-depth overview. So I have put the cases in bold throughout the presentation, and I'd recommend taking a note of them to look them up later if you'd like. Okay, so today we'll be looking at an in-depth overview of corporate governance, annual general meetings, so their frequency, requirements, and agenda, convening and recording attendance during a general meeting, voting procedure, quorum, and role of the chairman, motions and resolutions and the decision-making process, direct meetings, and written resolutions as well. Okay, so corporate governance is primarily the study of the power relations among a corporation's senior executives, its board of directors, and those who elect them, shareholders in the general meeting, and employees as well. It also concerns other stakeholders such as creditors, consumers, the environment, and the community at large, essentially. Okay, everyone, sorry about that. We just had some technical difficulties. So hopefully you can see the screen now. This is just the agenda for today. And as well, you must have missed the first screen for corporate governance. Okay, apologies about that. Hopefully we will continue as normal now. So corporate governance has also been more narrowly defined as a system of law and sound approaches by which corporations are directed and controlled, focusing on the internal and external corporate structures with the intention of monitoring the actions of management and directors, thereby mitigating agency risks, which may stem from misdeeds of corporate officers. So the rights and equitable treatment of shareholders. Of course, organizations should respect the rights of their shareholders and help them to exercise those rights. So they can help shareholders exercise their rights by openly and effectively communicating information and by encouraging shareholders to participate in general meetings. As well, corporate governance looks at the roles and responsibilities of the board. So the board needs sufficient relevant skills and understanding to review and challenge management performance. It also needs adequate size and appropriate levels of independence and commitment. So as well, it should encourage integrity and ethical behavior in the workplace. So integrity should be a fundamental requirement in choosing corporate officers and board members. Organizations should develop a code of conduct for their directors and executives that promote ethical and responsible decision making. And finally, corporate governance looks at disclosure and transparency. So organizations should clarify and make publicly known the roles and responsibilities of the board and management to provide stakeholders with a level of accountability. So all parties to corporate governance have an interest, whether direct or indirect, in the financial performance of the corporation. So directors, any workers, so employees, and management even, they receive salaries, benefits, reputation, while investors expect to receive financial returns. For lenders, it is specified in interest payments, while returns to equity investors arise from dividend distribution or capital gains on their stock, for instance. Customers are concerned with the certainty of the provision of goods and services of an appropriate quality. Suppliers are concerned with compensation for their goods or services and possible continued trading relationships. These parties provide value to the corporation. It may be in the form of financial, physical, and any other form of capital, really. So a key factor in the party's decision to participate or engage with a corporation is their confidence that the corporation will deliver the party's expected outcomes. So when categories of parties, such as shareholders or stakeholders, don't have sufficient confidence that a corporation is being controlled and directed in a manner consistent with their desired outcome, they are less likely to engage with the corporation. And when this becomes a system feature, the loss of confidence and participation in markets may affect other shareholders and increase the likelihood of political action. So there is substantial interest in how external systems and institutions, including markets, influence corporate governance. So directors are given powers for the day-to-day management of the company, and obviously they have a fiduciary duty to act in the best interest of the company as a whole. And members, it's just what's written on the screen here. They're also referred to as shareholders, and essentially they are the owners of the company, really. So a general meeting is a meeting of a company's shareholders, unlike a board meeting, which is a meeting of the directors. So the general meeting is for both the shareholders and officers to discuss the public details about the business. So for instance, what was the profit or loss, what things they accomplished, and then they can nominate as well other board members. And the board meeting is the directors and officers of the corporation. And there are generally two types of meeting or general meetings. So the annual general meeting, you can also see it being abbreviated to AGM, and extraordinary general meetings, you can also see it being abbreviated to EGM. So an extraordinary general meeting is any meeting other than the annual general meeting. And the directors may call general meetings whenever they wish, and this is as per Companies Act 2006, Section 302. And they must call a meeting of members holding 1/10 of the voting shares, or if 1/10 of the voting rights requested one. And then obviously, the annual general meeting, it's held on a yearly basis, and this is obligatory for most companies. So an annual general meeting is a mandatory public gathering of a publicly traded company's executives, directors, or any interested shareholders. And at the annual general meeting, the CEO or the directors typically speak, and the company presents its annual reports, which contain information for shareholders about the business's current performance and strategy, as well as their projected income, really. So that maybe the shareholders, if they're wanting to buy more shares, maybe if the company is not doing so well, they will decide to sell some of their shares. So shareholders with voting rights vote on current issues, such as appointments to the company's board of directors, executive compensation, dividend payments, and auditors. So shareholders who do not attend a meeting in person are asked to vote by proxy, which can be done online or even by post. So the general meeting is typically the only time during the year when shareholders and the company executives interact. So if a company needs to resolve a problem in between annual general meetings, they may call an extraordinary general meeting. And activist shareholders may use annual general meetings as an opportunity to express any concerns that they have about the business, or just really it can be anything, as long as it's not considered part of the agenda of the AGM. So, for instance, consideration of annual accounts, the declaration of dividends, the retirement and appointment of any directors, and the appointment and remuneration of auditors of the company. And this is as per Pender and Lushington. So, convening a general meeting, as per Hickman and Kent or Romney Marsh Sheep Breeders Association, a general meeting has to have a notice that a general meeting is going to take place, and it needs to have the length of the notice period, a clear day's notice, short notice, or service of notice. So this can be by post, special delivery, or even by email as well. And there is no requirement for a private company to hold an annual general meeting, although some companies' articles drafted when there was a statutory requirement to hold an annual general meeting will still provide for one to be held. So in such cases, the company must continue to comply with its articles until they are amended. And the usual business of AGM is to receive the annual accounts, the directors' reports, and maybe as well to elect the directors or auditors. And even if there is not going to be an AGM, to discuss any accounts that they still have to be distributed to the shareholders, etc. really. So the procedure for electing the general meeting. It varies obviously from company to company and is determined by the Companies Act of the jurisdiction that the company is located in, and as well the Articles of Association. So there are statutory rules governing the period of notice that must be given for a meeting. The minimum statutory period for any type of meeting is now 14 days. Though a company's articles may require a longer period, and a meeting can be held on short notice with the written consent of a majority. So the majority usually, obviously, yes, it does depend on the company's individual articles of association, but usually it should be 90 to 95% of the members, and that constitutes a written majority. So the Act provides rules on the right of members to distribute statements, the quorum, the chairman, any voting procedures, corporate representatives, adjournment of the meetings, any electronic communication, and the statutory provisions must be read in conjunction with the company's articles, which in many cases will be based on either of the model articles. So just going back to the case that you have on screen there, Hickman and Kent or Romney Marsh Sheep Breeders Association. So this is a UK company law case, and it concerns the proper interpretation of a company's articles and whether a company member or shareholder should be bound by its terms. So the contents of the notice that the general meeting is due to take place is it takes the full company name must be in the notice, the type of meeting that will take place, whether it's going to be an EGM or AGM, the place, date and time of the meeting, and a summary of topics to be discussed. And failure to give notice of these requirements may invalidate the proceedings of the meeting, or accidental omission actually sometimes does not invalidate the proceedings entirely. So an annual general meeting or even EGM, an extraordinary general meeting, called for the passing of a special resolution or a resolution appointing a person as a director shall be called by at least 21 clear days' notice. All other extraordinary general meetings shall be called by at least 14 clear days' notice, but a general meeting may be called by shorter notice if it is so agreed by all the members who are entitled to attend and vote, and in the event of other meetings by a majority in number of the members having a right to attend and vote, being a majority together, holding no less than 95%. So the notice shall specify the time and place of the meeting, the general nature of the business to be transacted, and in the case of an annual general meeting, shall specify the meeting as such. Okay, so subject to the provisions of the articles and to any restrictions imposed on any shares, the notice shall be given to all the members and to all persons entitled to a share in consequence of, for instance, so it's not just retirement, it can be, bankruptcy or death even of any shareholders, and as well directors and auditors as well. So the accidental omission to give notice of a meeting to, or the non-receipt of a notice by a meeting, this is by any person that is entitled to receive the notice, it shall not invalidate the proceedings of that meeting necessarily. It doesn't have to, really. Okay, so this is a typical agenda here. And the agenda provides a detailed list of all matters to be covered during the meeting, and not just the main business of the meeting. So this is a fairly standard agenda, which all members must receive before the meeting convenes. So as you can see, items included in the agenda are the receipt of apologies of those who are unable to attend the meeting, confirmation of who is present by proxy, a review and adoption of previous meetings, the business covered in the notice and other relevant business, the proposed date for the next meeting as well. So proxies, as we've kind of mentioned briefly before, it's a person who is entitled to attend, speak, or vote. The voting process can either be via a show of hands, or it can be via a poll as well. So at general meeting, it remains so entitled in respect of that meeting or any adjournment of it, even though a valid proxy notice has been delivered to the company by or on behalf of that person. So an appointment under a proxy notice may be revoked by delivering to the company a notice in writing given by or on behalf of the person by whom or on whose behalf proxy notice was given. So a notice revoking a proxy appointment only takes effect if it is delivered before the start of the meeting or adjourned meeting to which it relates. If a proxy notice is not executed by the person appointing the proxy, it must be accompanied by written evidence of the authority of the person who executed it to execute it on the appointer's behalf. So we'll look at the quorum now. So quorum is the minimum number of members or shareholders of an assembly or society that must be present at any of its meetings in order to make the proceedings of that meeting valid. So this is established as per the individual company, again as stipulated in the Articles of Association. So essentially a quorum, it's a number that is used on most notices or even in the Articles of Association. And if the number of members or even proxies falls below this number, essentially it means that the meeting will not be valid. So no business other than the appointment of the chairman of the meeting is to be transacted at a general meeting if the persons attending do not constitute a valid quorum. And Section 318 of the Companies Act 2006 provides that a proxy counts towards a quorum. And yeah, as you can see here, attendance may be in person or by phone or Skype. And yes, the Articles of Association contain the quorum for the respective company. So in quorum meetings, they are unable to proceed effectively because not enough members are present to make up a quorum. So in quorum meetings should be adjourned, as the business conducted at those meetings is invalid. Meeting could become inquirate if members leave halfway through proceedings. Only part of the meeting proceedings will remain valid. And single-member companies don't have general meetings. Instead, a written resolution is passed by a single member. And whilst it is possible for an inquirate meeting to continue in respect of items purely for discussion, it does not constitute a meeting of the board, and no business decisions can be taken by an inquirate meeting. So specifically, board members cannot, when inquirate, exercise statutory discretion, nor do the opinions expressed or conclusions reached by an inquirate meeting constitute those of the board. Okay, so the principal role of the chairman of the board is to manage and to provide leadership to the board of directors of the company. The chairman is accountable to the board and acts as a direct liaison between the board and the management of the company. This is through the CEO or Chief Executive Officer. The chairman acts as the communicator for board decisions where appropriate. The concept of separation of the role of chairman from that of the CEO implies that the chairman should be independent from management and free from any interests and any business or other relationship which could interfere with the chairman's independent judgment, other than interests resulting from company shareholdings and remuneration. So, more specifically, the duties and responsibilities of the chairman are as follows. So he will typically act as a liaison between the management of the company and the board of directors. Hopefully he will as well provide independent advice and counsel to the CEO. Hopefully he will ensure that the directors are properly informed and that sufficient information is provided to enable the directors to form appropriate judgments. So in concert with the CEO, he must as well develop and set agendas for meetings of the board. He must be able to review and sign minutes of board meetings, to sit on other committees of the board where appropriate, to call special meetings of the board, in concert with the CEO to determine the date, time, location of the AGM, and to develop the agenda for the meeting, or this is also called the notice as well that we looked at earlier. So as well, he should recommend to the board, after the consultation with the directors, management, and the governance and nominating committee, the appointment of members of the committees of the board. As well, he should assess and make recommendations to the board annually regarding the effectiveness of the board as a whole and the committees of the board and individual directors. So to ensure that regularly, upon completion of the ordinary business of a meeting of the board, the directors hold discussions without any management present as well. So before the meeting takes place, the following points must be established. So the type of meeting that's going to take place, where it will take place, and when it will take place, who will attend and who will be absent, the chairman who is elected, who will be the note taker or the person taking the minutes, confirmation that the required period of notice for the meeting has been given, and as well a confirmation that the meeting is quorum. And if any of these have not been fulfilled, the meeting will be considered void and all resolutions passed will not be valid. So it's really important, these bullet points here. So resolutions now. We will look at ordinary resolution and special resolution. So an ordinary resolution of the members of a company means that a resolution that is passed by a simple majority, so simple majority is 50% or more, and a special resolution of the members of a company means that a resolution passed by a majority of no less than 75%. So an ordinary resolution is the most common method by which a corporate entity conducts its business, or the board of directors seeks shareholder approval of its actions. So the prevailing legislation applying to companies in the relevant jurisdiction will usually prescribe certain activities which must be approved by special resolution, or alternatively cannot be approved by ordinary resolution. For example, altering the company's constitutional documents, reducing the share capital, or dissolving the company. So these are examples of things that are really detrimental and important to the company. This is usually when special resolution is required. For general decision-making procedures and day-to-day tasks, usually it's when ordinary resolution will be required. So in addition, in certain circumstances, a company may wish to amend its constitution to increase the threshold, to provide that a special resolution needs to be passed prior to the company engaging in other matters which may ordinarily be approved by a simple majority, purely as a matter of internal organizational control. So voting at general meetings. So a resolution put to the vote of a general meeting must be decided on a show of hands unless a poll is demanded in accordance with the Articles of Association. So in case of any errors or disputes, no objection may be raised to the qualification of any person voting at a general meeting, except at the meeting or adjourned meeting which the vote objected to is tendered, and every vote not disallowed at the meeting is valid, of course. So any such objection must be referred to the chairman of the meeting, whose decision is ultimately final. So poll votes as well. So this is sort of voting as if you would in an election, really. So you write down your answer or usually tick a box and it's voted for that way. It's usually a lot more private than a show of hands, obviously. So a poll on resolution may be demanded in advance of the general meeting where it is to be put to the vote, or at a general meeting, either before a show of hands on that resolution or immediately after the result of a show of hands on that resolution is declared. So a poll may be demanded by the chairman of the meeting, any of the directors, or even two or more persons that have the right to vote on the resolution. So it's most likely shareholders in this case. So as well, a demand for a poll may be withdrawn if the poll has not yet been taken, or the chairman of the meeting consents to the withdrawal, And as well, polls must be taken immediately and in such manner as the chairman of the meeting directs. And an adjournment as well. So stopping the meeting is called an adjournment. It can be just stopped indefinitely or for a certain period of time, for example, 1 or 2 hours. That's completely fine as well. So the business, as set out in the notice or agenda, is then dealt with item by item. And once a decision has been reached, the term "it was resolved" should be stated. So any other business covered by those present, and the chairman must give notice that the meeting has finished, and the total meeting time as well must be signed by the chairman. Okay, sorry, I think that you can see the screen now. Just let me know if you can't see it. So directors' meetings, they are different from general meetings, and you may also hear them being called a board meeting. So this is completely separate from any general meetings. And Barron and Potter is a UK company law case concerning the balance of power between the board of directors and the general meeting. It stands for the principle that when the board is incapable of taking action, power to conduct the company's affairs will revert to the general meeting. So in the case, Mr. Barron was not on speaking terms with Mr. Potter or the other director of a London-based company. So the Constitution, the company's articles essentially, said that the quorum for a valid meeting was only 2 people. So Mr. Potter was also the chairman with a casting vote. However, Mr. Barron was refusing to come to meetings. So, on the 23rd of February 1914, Mr. Potter came to meet Mr. Barron as he got off the train at Paddington Station. He told Mr. Barron that they were now holding an official board meeting on the platform. He proposed appointing more directors, and Mr. Barron objected. Mr. Potter said he was using his casting vote, and he effectively declared the motion. So there followed a general meeting at which new directors were again said to be appointed, and again with Mr. Barron's objection. So Mr. Barron sought a declaration that the appointment of the directors were ineffective, arguing that the meeting at the train station was not a meeting, and that the general meeting's resolution was therefore invalid, since the board was the only organ that can appoint more directors. So Lord Warrington, in this case, held that in view of the deadlock, the power reverted to the general meeting, and in this case, the appointments were valid. And there had been no proper board meeting on the train platform. However, the shareholder meeting which took place afterwards was effective. So essentially, the rulings of members at general meetings can even overrule directors' wishes if they like. So it's interesting, this case, because when we're discussing corporate governance, and the topics such as acting in good faith, making sure everything is fair and even, it sounds like it's common sense, but if you look at this case, it's very often that sometimes people in companies, they can fall out, or essentially just things don't go to plan, and this is where corporate governance takes effect, really, and the articles of association. And this is why really we have it, because it just offers another barrier of protection, to keep your rights really, really well kept. So the same general principles apply to director meetings. There needs to be an agenda established prior to the meeting convening. Can also be called the notice as well. So there can be an alternate director to attend in the place of another, as long as they have the same standing and authority. Actually, there's something different here. Proxies are not allowed in direct meetings, but the same rules apply to the quorum for general meetings. So, Attorney General and Davey is a UK company law case which establishes the small but essential point of law that the default rule is that a majority of a corporate body can determine what it does, essentially. So decision-making process. Directors, to take decisions, they must do so collectively. And the general rule about decision-making by directors is that any decision of the directors must either be a majority decision at a meeting or a decision taken in accordance with Article 8, so long as the company only has one director and doesn't have any provisions in the articles requiring it to have more than one director. The general rule does not apply, and the director may take decisions without regard to any of the provisions of the articles relating to directors' decision-making. And unanimous decisions. So a decision of the directors is taken in accordance with this article when all eligible directors indicate to each other by any means that they share a common view on the matter. So such decision may take the form of a resolution in writing, copies of which have been signed by each eligible director, or to which each eligible director has otherwise indicated in writing. So references in this article to eligible directors are to those who have been entitled to vote on the matter, and it has been proposed as a resolution at directors or board meeting. So a decision may not have been made in accordance with this article if the eligible directors would not have formed a quorum at the meeting. So the same applies for general meetings to board meetings as well. So a member's resolution is considered effective because it carries the signatures of all members, so the shareholders and stockholders entitled to vote, even if it was not presented for approval at a properly convened meeting. So this is an exception to the general meeting requirements, and a company can use this method to quickly pass a resolution without having to arrange a meeting. And this was established in Kane and Jones, which you can see on screen there. Okay, so that concludes today's webinar. Thank you so much for everyone that participated. I hope that you found it useful, and I'm so sorry for all of the technical difficulties that we had today. Hopefully it didn't impact it negatively for you too much. So you can find recordings of today's webinar at Eltoma-Global, as well as being able to request new topics that you would like to be presented in the future. Okay, have a nice rest of the day. Bye-bye.